Hi, everyone. Thank you for joining our webinar today over your lunch hour. My name is Lola Adebogun, and I am West Marketing and Admin Assistant. Our topic today is how to properly protect your business name. This is the third part of our five-part webinar series titled Top 5 Legal Matters for Entrepreneurs to Consider. The remaining two topics in this series will be taking place every Wednesday in January. While I'm talking, I'll leave this slide up with our 5 legal topics to give you a sneak peek of what's to come. Registration is now open for the rest of the webinars in this series. Today's webinar will be presented by Luann Schlosser, who is the founder of Lunaville Law. If you have any questions for Luann as we go through the presentation, please feel free to submit them in the Q&A box, not the regular chat box. However, do feel free to use that regular chat box to introduce yourselves and tell us a bit about your business. And as always, this webinar is being recorded and will be available for on-demand viewing. You'll receive an email tomorrow at this time with a link to the recording. With that, I'll pass it over to Luann to now begin the presentation.
Good afternoon, everyone. Can everyone hear me all right? I'll just get the WESC mods to tell me if I can be heard properly right now.
Yeah, it sounds good.
Okay, great. So I will get started here. All right, and is the slide deck visible now?
Not yet.
Let's just go here. All right, is the screen or a slide deck visible now?
Yes, it is. Thank you.
Okay, wonderful. So thank you all for joining us today. A big thank you to WESC for having me present on this topic today. A little bit about myself. I have been practicing law in Saskatchewan for over 10 years now. I started with a medium-sized firm in the city, and then I went to a national firm where I really got my legs underneath me in terms of my intellectual property law practice. And I focused mostly on trademarks in that practice. So after spending some time there last year in February 2020, I decided to launch my own firm. And the model was a virtual practice, which was great timing in light of the pandemic happening 1 month later. So I've been practicing virtually as a result of choice, but also as a result of the pandemic. So it's nice to have some interaction, though, by way of video conferences from time to time, I must admit. So today we're going to talk about protecting your business name and sort of what the provincial requirements are, and then what you can do to have a stronger reputation for your business name and brand across Canada. So the first thing I guess we would want to take a look at is business names. So when you do business in Saskatchewan, you have a requirement to register a business name or a corporate name if you are going to be doing business under a name other than your own. So for example, if I was just, having a service, if I made candles and I just called it, Luann Schlosser, and people knew I sold candles, well, that's fine. I don't need to register anything in addition to that because I'm using my own proper name. However, if I wanted to sell my products under the name Candle Joy, then I would have to do something about that name because I'm no longer operating under my own proper name. I'm operating under some other name. So I have to register that name. So I have a choice. It might be the case that I decide to operate as a sole proprietor. And if that's the case, I'm required to register my business name as a sole proprietor. So as a sole proprietor, I would have to decide what I want to call my business, and I would have to adhere to the Business Names Registration Act. That's a provincial piece of legislation in Saskatchewan. So I would have to adhere to that, register my business name, and then I could sell under Candlejoy. Now, in terms of a corporate name, same thing applies. So if I decide instead I want to run my business through a corporation, say for tax purposes or liability purposes, and that discussion is not subject of this presentation today, but if I decided to run my business as a corporation, well, there's still naming requirements for my corporation as well. So under the Business Corporations Act, I would have to adhere to their naming protocol. So again, these requirements doing business in Saskatchewan, they're provincial and they're regulated by our provincial legislation. So each jurisdiction has very similar rules. So across the board in Canada, the territories and provinces do have similar rules in terms of how you operate a business if you're operating under a name other than your own. In Saskatchewan in particular, whether you're operating as a sole proprietor or a corporation, the requirement is that you must have a distinctive element and a descriptive element to your name. So as you will see in my example here, Lunova Law, Lunova is the distinctive element. That is a made-up word, and then law is the descriptive element. It signals to the consumer that I'm likely providing law and legal services, right? Now, in terms of corporations, they have the same requirement, but then they also have to have their corporate suffix. So that's either Inc., corporation, corp, LTD, and that suffix you choose, it doesn't matter. It's typically a preference thing. So that's sort of the further requirement with a corporation. Now, for me, I have a corporate name, so I'm incorporated. My incorporated entity is Luann Schlosser Legal Prof Corp, but I am not presenting to you today as, you know, Luann Schlosser Legal Prof Corp is providing a presentation. It's Luann Schlosser of Lunova Law. And so the way that works is I've got my incorporation, so I've got my corporate entity, and then my corporate entity, because it's operating under a different name, that being Lunova Law, it owns the business name, Lunova Law. So that's how we deal with the naming requirements provincially. And in Saskatchewan, because I've registered Lunova Law, and because I also have Luann Schlosser Legal Prof Corp registered, if someone were to come along and wanted to register, for example, Lenova Law in Saskatchewan, they would not be able to because that's too close to my business name. So I have protection in Saskatchewan because I've registered my business name. I'm incorporated in Saskatchewan. I've done my due diligence. I'm all set up, all good to go. So a lot of people do this. They do their work. They get set up in Saskatchewan, off to the races, off to do business. Fantastic. But the issue I see sometimes is, especially right now, that a lot of people are taking their business online and we're seeing e-commerce, people will all of a sudden go, wait a minute, there's someone in Ontario who's using pretty much the same name as I am. That's not allowed. I registered my name in Saskatchewan. And I unfortunately have to tell them, yes, you have your name registered in Saskatchewan, but that protection is limited to Saskatchewan. It does not necessarily extend to Ontario. And because each jurisdiction across Canada has their own policies in terms of vetting names for businesses and for corporations, there's not necessarily coordination amongst the provinces. And so it is very possible, and I've seen it happen on a number of occasions where two businesses, you know, one, for example, in Alberta and one in Ontario, have very, very similar names and are offering identical services. And when you take that and you put it into the larger scheme of things, if you're online, for example, selling online where there really are no borders, you can see how that can become problematic. So that's why one thing to consider is a trademark. So we'll talk about that next. So trademarks are interesting because they are federal in nature. And so what I mean by that is when you get a registered trademark in Canada, you end up having rights to use that name across Canada for the goods and services for which it is registered. So that's an important distinction. You can register your business name as a trademark in Canada, but you don't get carte blanche to prevent everyone in the world from using, or everyone in Canada from using that name. So for example, back in the day, there was an airline called Canadian Airlines, and Canadian Airlines could have the name Canadian for their airline, and Canadian beer could have their name Canadian, because they operated in completely different markets, right? One is a beer provider and one is an airline provider. So when you register a trademark, you're registering it in relation to the specific goods and or services that you're providing. So trademarks serve as source identifiers. And really it's how people decide whether they want to purchase, Nike footwear versus Adidas footwear. They may have an affinity to the brand Nike because they know that brand, it's been around maybe longer, or they've had a good experience with that brand. So that is how that trademark serves to distinguish the goods of Nike. Nike presents or represents that global brand of fitness, gear, and apparel. And generally anything that represents your brand can potentially be trademarked. So not only can the name be trademarked, so let's take, for example, Kit Kat chocolate bars. So the name Kit Kat is trademarked, that's for the chocolate bar. And then if I remember correctly, I think there's a slogan as well. I think it's, have you had your break today? Maybe that's not the right one. And I'm probably getting this wrong, but you can register a slogan as well in relation to your product. So anything that represents your brand can potentially qualify for a trademark. And as you will see at the bottom of this slide, a trademark may also be the same as your business name, but that's not always the case. So going back to my example about my law firm, I have a corporate name of Luann Schlosser Legal Prof Corp. Well, that's not how I'm branding myself in the marketplace. When I'm promoting myself to potential clients, I'm promoting myself as Luann Schlosser of Lunova Law Firm. So Lunova Law is actually my trademark. And it's also registered as a business name in Saskatchewan. The difference is that as a registered trademark, once and if it gets secured, I have rights across Canada to that name. Whereas right now, I can only operate Luann as Lunova Law. I only have those exclusive rights in Saskatchewan with a business name. The business name gives me the rights in Saskatchewan, but once I have the trademark, then I have rights across Canada. So going back to the different types of trademarks, again, it's anything that can essentially serve as a source identifier of your business. So if someone sees that type of mark, they go, oh, that's X business or Y business. So the types of trademarks that we are seeing, we have words. So we talked about that. So for example, Nike, Coca-Cola, Lululemon, Coors Light beer. Slogan, have you had your break today? I'm sure there's other slogans you can think of with other companies, or sometimes they're referred to as taglines. Symbols. So sometimes we don't have necessarily a word, we have a symbol. So we have, the Lululemon, that own symbol, or for Mercedes-Benz, we've got that circle with the sort of star triangle in the middle. Now in Canada, we have a few more trademarks that people can register, and this is fairly new and unique. So in 2019, we had a big overhaul of our federal trademarks legislation. And when that happened, the goal of that overhaul in part was to bring our legislation in line with the rest of the worldwide trademark legislation. And so as a result of those amendments, we sort of opened up the parameters in terms of the types of things you can trademark. So you'll see on this slide that you can also trademark sound, smell, taste, color, hologram, 3D shapes, and modes of packaging. So let's just talk about those for a little bit. So right now in Canada, the legislation is still fairly new, having just been rolled out in 2019. And I know that's a few years ago, but in the trademark process, from application until registration, it usually takes about 2 to 2.5 years. So it's actually not that long when you're looking at the lifespan of a registration or application to registration. So once these amendments were made in 2019, we saw a bunch of companies apply for what we call novel trademarks. So these are the ones, smell, taste, color, hologram, those things that you typically wouldn't trademark until recently. So with the smell trademark, this is an interesting one. Crayola has actually applied to have their scent of their wax crayons trademarked. And when they file the trademark, I have it here, they have to put a description of the smell. And the description is a unique scent of pungent fragrance combined with a faint scent of hydrocarbon wax and an earthy clay. So Crayola's actually filed a trademark for that. And if successful, what does that mean? Well, it means that any other person who sells crayons, markers, anything of that related nature, they would not be able to have a formulation that smells like a Crayola crayon. So I know that sounds kind of crazy. And in some respects, I think some of these companies are simply registering these novel trademarks as a bit of an experiment, but it does add value to the brand down the road. Another example is in the US, there's a registration for the smell of Play-Doh. So if any of you guys can remember, or if you have children, there's the smell of that Play-Doh that comes in the yellow container, and that has been trademarked. So that's always a very interesting thing too. Sorry, my screen just stopped sharing here. Can everyone still see my screen? My screen just went off.
Yeah, we can still see the screen.
Let me just move this here. Sorry about that.
If you could, let me just message.
And the slide deck is still present?
The slide deck is not present. Let me share my screen really quick while you try to open up. Let me know once you have the slide deck open up again.
So I'm getting a message, you cannot start share screen while the other participants are sharing. So you'll have to exit yours. All right, sorry about that. My computer decided that it wanted to update my Adobe, and I think it booted me out.
That's completely okay.
So going back to these unique types of trademarks. So we talked about the scent one. The modes of packaging, that's an interesting one. So Chanel handbags, they've applied to trademark their one of their bags, and I believe it's what is it called here? It's their boy bag, or it's the very standard Chanel bag with the quilting. So they've applied for a trademark for that particular 3D shape. And Birkenstock actually did the same thing for their sandals. In terms of taste trademarks, which, I mean, those are even more out there in my opinion, there's an applicant called Endurance Tap Incorporated, and they filed a trademark consisting of the taste of salted maple syrup with ginger in relation to energy gels, energy bars, and dissolving powder for energy drinks. So what does that mean? Well, that means that if they're successful in getting that trademark, no other company providing those same products could get a trademark for taste, and no company providing those same products could formulate their products potentially to taste like that. And so again, we haven't seen the final outcome of these novel trademarks because they're still in the application process, but something to monitor and to sort of keep our minds to, because we are seeing more of these now with the amendments to the legislation, and it presents another way for companies to sort of set themselves apart in the marketplace if they have like the exclusive right to a smell or a taste, for example. And then, of course, the sound trademarks are not as unique. These have been around for a while, so If you think of Dolby surround sound, if back in the day when we could go to a movie and they were using Dolby surround sound, at the beginning of the show, you would hear that Dolby kind of blast. That would be a trademarked sound. Same with the lion. For, I forget which movie company it is, that roaring lion, they've actually trademarked that too for sound. So as you can see, there's different ways to trademark unique aspects of your brand to protect them and to prevent others from using those same sort of unique aspects in relation to similar goods and services. So going back to our trademarks, the most common, of course, being a word mark. So that's just the written word. So Nike for athletic gear, a symbol, a straight design. So the symbol for Lululemon athletic clothing, I would say most people in Canada, at least when they see that symbol, they know exactly what it's used on. It's, you know, used on athletic and yoga related comfy clothing. I'm sure a lot of us have been wearing a bit of it these days. And then there's the stylized word. So it's basically like a marriage of a word mark with the symbol. So for example, Coca-Cola, you can still see the words in it, but it's a stylized word mark. So those are the most common marks that people register. And there is some strategy in terms of how you register a trademark. My recommendation always is if you have a bit of a limited budget, always register the word mark first. The reason for that being is that a word mark is, you can adapt it into different stylizations down the road. So if you register Nike, you can, you know, have a, or if you registered something like Nike, of course you couldn't register Nike, but if you registered a word mark like Nike, you could eventually take that word mark and stylize it into a logo. Whereas if you, so that's if you have a limited budget. Whereas if you have a bit of a bigger budget, you might do the Nike word itself and then the swoosh mark. Your trademark strategy is really going to depend given what your goals are. So that's something you would have to discuss with your trademark attorney, but there's different strategies in play. And a lot of the time people want to register their logo first. And I think that's sort of misguided because the problem with logos is when you file a logo, so when you register a logo, you have to use that logo exactly as filed. So the problem with logos is, you know, as sort of brands evolve, sometimes the logo changes slightly, and slight changes are typically permitted. But when your logo changes too much, there is an argument that you're no longer using your trademark as filed. The problem with that is if you're no longer using your trademark as filed, it loses its validity and protection, because one of the main things that you need to do for trademarks is you have to continue using them in commerce. So if you stop using your trademark, you lose it. So we always tell clients, use it or lose it. So again, with a symbol like a design, if you start modifying it over time, the argument is, you know, what you filed and what you now have are two different. You're no longer using it as filed. Your old logo is no longer valid. And so you can run into some issues there. So there's different filing strategies to be aware of. And those are some things you need to communicate with your lawyer or your trademark agent when you're developing your brand strategy. So advantage of trademark registration. So as we said before, trademark rights are national. So these are enforceable across Canada. So this is the important part, I think, because if you want to potentially sell across Canada, as is the case with a lot of e-commerce, you need that right to do so across Canada. And if you don't reserve that right by filing a trademark, there's a strong possibility that another person, say for example, I keep using Ontario, someone in Ontario registers a very similar brand, and you have your business name registered in Saskatchewan, but all of a sudden, if that Ontario entity decides to register a trademark, very similar to just your business name, their rights are going to be national. They're going to have rights across Canada potentially, and your rights are going to be limited to your province. And if you don't get wind of it in enough time, there's a 5-year period for incontestability, they can down the road tell you to stop using your brand name in Saskatchewan. So there are some problems that you need to be aware of, that if you want the ability to sell across Canada And if you want to ensure that your brand is protected to the fullest extent, then you do need a trademark. So a trademark is, the rights are national, and that's probably one of the biggest advantages of the trademark registration scheme. And then protection against future third-party registrations. So once you do have a trademark that's registered, many provincial jurisdictions, when they do their nuance, their name searches for business corporations or business names, if you have a trademark, that will come up as basically a block, and it will tell this entity trying to register their provincial name, no, sorry, you cannot have that name because there's a federal trademark. And so that prevents against these potential future third-party registrations. So it's essentially like a shield against new businesses coming up that have, decided to use a similar business name to yours. It basically allows you to prevent this by having that on the public registry. Another advantage of a trademark is that trademarks usually appreciate over time. And I put usually in brackets there because not always. Sometimes brand owners do terrible things or are a bit tone deaf when it comes to social or political issues. And you can see oftentimes how that affects their brand when their stock dives down in the markets if they're publicly traded. So usually though, if used properly and you have a strong strategy in terms of growth, your brands will appreciate over time. The more you use them, the more well-known they get, right? So Lululemon, I remember when it first came out, I thought, well, this is nifty and comfortable athletic wear, great. And the brand was nice, and the product was nice, and I liked how the product wore over time, and I decided to buy more. And I mean, everyone all of a sudden decided Lululemon was a great product, and that brand exploded. And so that brand, they've done a pretty good job to appreciate their brand over time. Their reputation now spans more than just in Canada. Oftentimes when I'm watching a TV show, I can see people wearing Lululemon branded clothing because I can see that little OM symbol sticking out. And then another thing to consider is when and if you do decide to sell your business, oftentimes there's value that is attributed to your brands. So I've done some transactions in the past where one of the biggest value points in the merger, the acquisition, was getting this portfolio of brands, because brands, when attached to the proper products, they sell more. Brand names that are well known, you can sell that product more than just a generic product, right? Another advantage of trademark registration is the enhanced ability to license. So some people, for example, will start out with a business locally and they do very well with it. They register a trademark and they go, okay, well, I've done so well in Saskatchewan with this business, particular, Saskatoon, Regina, maybe I'm going to test out the market in Edmonton and Calgary. So then they set up, let's just call it a pizza shop. So they set up pizza shops under the same brand, the same trademark in Calgary and Edmonton. So now they've got 4 locations. They've got a series of shops operating under that name. And then they get approached by someone saying, hey, what do you think about your business becoming, a franchise? Could we buy into your business as a franchisee? So again, when you look at things like Tim Hortons, that started out as a sole coffee shop. And then people bought in to operate their own Tim Hortons shops as franchisees. And the owner of the Tim Hortons brand used that brand to essentially sell the idea of a certain type of coffee shop. And it has been wildly successful. Same with Starbucks or any other sort of franchises you can think of. And by having a trademark, you have the ability to expand that way. Without a trademark, it's very difficult to offer someone a franchise because you have no intellectual property right, no certainty into that name. So what is the person buying into, right? So a trademark definitely will enhance your ability to franchise and expand to multiple locations down the road. And then the next one is domain names and social media recourse. So this happens a lot where I see people register a business name or a trademark in Canada. And because the Canadian Intellectual Property Office and the business names registry are public, people can search those business names. And there is an increased incidence of people searching these registries and then applying for domain names with those brands. And then what they do is when the person goes to secure their domain name, if they haven't done so already, they essentially extort money and say, we will not give up the domain name unless you pay us X amount of dollars. By having a trademark, a registered trademark, it actually gives you the ability to dispute these domain names and to remove cyber squatters through different processes set out. So there's different processes for .ca names than .com names, but a trademark will definitely assist in those types of proceedings. The other thing is social media platforms. Their terms of service and terms of use differ, but a lot of our social media platforms, the main ones, have terms and policies about using other people's trademarks. So they typically are very preferential to trademark owners. So if you have a trademark and there's someone using a very similar social media name or using a very similar brand and it's confusing, often you'll have recourse against them if you have a registered trademark. So those are some of the advantages of having a trademark rather than just the business name or the corporate name. These are not all of the advantages. There's more advantages, but these are sort of the main ones. And again, I think the biggest one is that when you register a trademark in Canada, you typically get those rights across Canada. So you provide yourself the greater ability to expand your business, to sell online. You're not limited to a tiny, provincial box, I guess. So developing a strong brand. This is always a fun exercise for me and my clients. And too often I see people putting the cart before the horse. And what I mean by that is I've had a number of clients come to me where they've developed their brand. So they've registered a business name in Saskatchewan or a corporate name or both. They've developed their marketing materials. They've got their colors, they've got their logos, they've printed off their signs. They're just, ready to go. But what they haven't done is really thought about whether or not, number one, do I have a strong brand? Number two, is my brand going to be something I can scale up down the future? And so one of the main things I always tell people when you're starting a business, think about what it is you're doing. So what service are you providing? What good are you providing? What is your goal? What is the message? What is the brand? What is your message? What are you trying to convey to your target market of consumers? So when selecting a trademark, so again, the trademark might be the same as the business name you registered. It might be different, but when selecting a trademark, so your brand, you need to be aware of the difference between a strong and a weak trademark. So a strong trademark will distinguish the goods and services from those of your competitors. A weak trademark won't. So there's typically 4 categories of trademarks. One is a fanciful trademark. Second is the arbitrary trademark. The third is a suggestive trademark. And the fourth being a descriptive trademark. And again, I've ranked these from strongest to weakest. So on a fanciful trademark, these are coined trademarks, invented words with no known meaning. So I put the examples of Twitter, Google, Xerox. These, when you hear them, you know what they are, and you know what goods and services are provided under them. But these words are made up. They're not regular words, they're coined words. So those are the strongest because it's unlikely that a competitor would be using a similar or made up word because you're the one who made it up or your marketing team made it up, right? For example, I chose Lunova law. It's made up, right? It's not a real word. So that's the strongest type of trademark. The second type of trademark, the arbitrary trademarks, these are known words. So real words, found in the dictionary, Google is now found in the dictionary, but it wasn't always, but known words found in the dictionary, but they're applied to unrelated products and services. So I put the example of Apple for computers. You know, that's a word that exists, but it doesn't represent food, it represents computing devices. Next, we have, so this is kind of getting into the weak area, we have suggestive trademarks. So these are words that are, you know, regular words that suggest a quality of the product or service, but they don't describe the product or service itself outright. So whirlpool, you know, there's some connotations in terms of what a whirlpool is. That's for washing machines. And what a whirlpool does, well, that's sort of suggestive of what's being provided. Copper tone for tanning oil, right? Not that we should ever be using that, but tanning oil, you know, to get that copper color, that copper tone of skin. So these types of trademarks are suggestive of the goods and services that are being provided under them. The problem with that is that in many jurisdictions, and certainly in Canada, there is a prohibition on trademarks that are clearly descriptive of the goods and services provided under the trademark. So when you file a trademark, it gets examined, and that is one of the grounds upon which it will be examined. So if you did use a suggestive trademark for your product or your service, you might get an objection back from the examiner saying, sorry, not going to register this because it is, you know, sort of descriptive, or clearly descriptive is the term, of the goods and services you're providing. Try again. So you can craft arguments against that, but once you get into these suggestive and descriptive trademarks, you will run into issues with the trademark examiner. Now, moving into descriptive trademarks, these describe goods and services, or you know, a fundamental inherent quality of the goods or services. And I see brand owners wanting to use descriptive trademarks all the time because, you know, I understand the argument. It's, well, I want the consumers to know what it is I'm providing. So I want to incorporate a description in my brand. And it's like, well, no, because that's a weak trademark, because the Intellectual Property Office will likely not register it. And it doesn't make a strong trademark, because if you want to describe what you're providing, like a bicycle store. So if you wanted to call your bike shop bicycle store, well, so many other people in that industry will want to refer to their stores maybe as being bicycle stores. All of a sudden we've got very similar brands and they're confusing. So that's why they're weak. As soon as they become a little bit generic and anyone can kind of use them, that's a weak trademark. So the strongest is coming up with a coin term. And I understand it's risky, because you're going, well, how is anyone going to know what I'm providing? Well, that's where your strategy of rolling out your products and services come in. You have to roll out great products, great services tied to that trademark. And then when people see that trademark, going back to Lululemon, they know exactly what it is you're providing. So again, once you've come up with your sort of preliminary list of brands, your trademarks that you want to use, I would caution going to register right away, because you need to do what I call your due diligence. If you cut corners on searching whether or not the trademark is available, you might run into issues in terms of, you know, you put your application in, the process is quite long, 2 to 2.5 years, and you might not get your trademark. In the interim, you've spent probably a lot of time building up your brand, advertising, marketing, branding your social media, all to find out, oh, there's already something out there like this, and it's confusing, and now my trademark is not allowed. Back to square one. So prior to getting into you know, the investment of money into your brand, your look, your marketing materials, your signage, your social media, your registering of domain names, all of that stuff, the first step is doing a trademark availability search, in my opinion, because that will give you a pretty good idea of what is out there that could potentially be considered confusing with what you want to use as your brand. And it'll give you a good idea of what is maybe similar. So in trademark law, a competitor brand doesn't have to be identical, as long as there's some confusion. So if the competitor has a similar name to what you want to use, they don't have to be identical. If they're similar enough, your trademark will not succeed. So a lot of people will do their due diligence by going onto the internet, Googling. They'll go on to the Canadian Intellectual Property Office database, which is public, and you can enter in trademarks to see what's there, and they'll see that nothing comes up, and they'll do their searches that way, which is better than nothing. But the problem with that is the public searches and the Googling, they do not pull a deep enough scope, and typically they'll only flag direct hits. They won't flag phonetic equivalents. They won't flag anything that could be considered confusing, even though it's not identical. And the problem then is you have a false sense of security. You go and you register your trademark, and like I said, you've spent all this time investing into your brand, your social media, your marketing materials, and then you don't get that trademark, and you find out that you might be in trouble because it's too close to someone else's trademark, and then you have to do the whole rebranding exercise. It's very expensive, and it could have been avoided if you simply did the trademark search in advance. So again, that's always my recommendation. Do a full scope trademark availability search if you have any desire to sell outside of Saskatchewan and you want a trademark. Scope of brand. Now this is always a difficult point too, because when people are starting up a business, they don't know if their product or service is going to take off. They don't know if it's going to be well received in Saskatchewan, Canada, or even abroad. But there should be some consideration about what your goals are, now and into the future. If there is, or if there are any sort of expansion goals to sell into the US or to sell into foreign markets in the EU, Australia, if you have that on the back of your mind, and to any degree, that should be something to be considered in the whole branding process as well. With e-commerce, especially now during a pandemic where there's way more shopping online, way more services being provided online, it really has reduced the borders. We can provide services theoretically and goods across the world. But if you are selling something under a brand that already has a brand that's very similar in another jurisdiction, you could run into hot water for trademark infringement. So these expansion goals should always be at the back of your mind when you're developing your brand, because if you do have a strong desire to potentially expand to foreign markets or even to the US, which is very typical just given our geography, you want to do the searches in the right jurisdictions and consider whether your brand is available there too. So again, coordination of a trademark portfolio is often left later in the business, because I get it. There are so many startups when you're building a business, or so many startup expenses. There's so many things, and thinking about your global brand potential is so much in the back of your mind at that point. You're thinking about the immediate, but again, thinking about these goals can help you, because if you have to rebrand in foreign markets down the road, it can be quite expensive. So I always put this hypothetical scenario, and this hypothetical scenario has played out for many of my clients. So local business begins producing a product or service in small batches, never thinks about global expansion. We have great communities in Saskatchewan. I think we have great supportive communities for new products and services. If we do a good job, people typically latch on and promote it. So by starting small, we develop a product or service that is high quality, well received in the community. Our product service begins to get traction and notoriety. Everyone wants this type of shirt or this type of service. And the success is proof of concept that our business is working. Our business is ready to expand into other markets. Our product is so good, we might even sell worldwide. And then we're getting ready to do some branding and to sell into foreign markets. And we realize there's already a brand for this skincare line in the UK, roadblock. So a failure to consider which target markets you may wish to expand into can be damaging, costly, and even embarrassing. So I put some fun examples to sort of close out our presentation here. So the first example, Australia. Burger King was not allowed to get the trademark for Burger King. They had to rebrand to Hungry Jack's. That was required because there was a pre-existing company in Adelaide that had Burger King in advance of Burger King getting into the Australian market. So as you can see below, kind of an interesting discussion here in terms of what they've done. So they renamed their Australian burger joint to Hungry Jack's. And they did a good job with their branding, in my opinion, because they have logo marks registered. And the Burger King logo mark is essentially identical to their Hungry Jack's logo mark. So what they did is, because they couldn't have the word mark, the Burger King word mark, they used their stylized logo and used a different name, Hungry Jack's, and rebranded in Australia. But when you look at both of the logos, you sense that there is some relationship. And of course, they're the same. It's just that Hungry Jack's is the Australian version. And Hungry Jack's, you know, if you want to know the story on that one, Burger King was developed out of Jacksonville, Florida. So Hungry Jack's, that's how they came to the name. So they did a good job with their branding because they had both a word mark and they had the logo mark. And so when they had to do a different name in Australia, they took advantage of the notoriety of what their logo looked like and then just changed the name. Example 2, so Mercedes-Benz entered the Chinese market under the name Benzi. And they didn't really do their market research there, and Benzi translates to rush to die. So, you know, not sure too many people want to buy cars where the sort of the message, the tagline is rush to die. So Mercedes-Benz missed the point there. Nike, they had to recall thousands of sneakers when they did some stylization of their brand on the back of their sneaker, and it resembled the Arabic word for Allah. So they had to recall all of those products and just destroy them. Example 4, Coors Beer used its slogan, "Turn it loose," in Latin America. And they didn't realize that, you know, maybe that sort of slogan catchphrase in Canada, the US, would translate to something very undesirable in that part of the world, because essentially turn it loose is sort of slang for having diarrhea in Latin America. So again, of course, beer missed the point there. So as you can see, there's a few takeaways from this presentation, hopefully. Business names and corporate names, you have to register those in the province that you're doing business. That's a requirement under provincial legislation. And they're going to provide you with limited protection for your brand in Saskatchewan or whatever other province you may have registered those business names. A trademark, on the other hand, is going to provide you protection across Canada. If you want protection across the US as well, then you would register a federal US trademark. So trademarks are federal by nature in most jurisdictions of the world, and you would register them with their federal registry. Trademarks are becoming even more important now, just given the fact that this year has been the year of e-commerce, anything from taking traditional services like spin classes or dance classes and putting them online because we can't gather, selling products online because stores are being shut, there's lockdowns. So, you know, e-commerce was always a big thing before the pandemic, but now so more than ever. And then emerging businesses should give some thought at least to brand strategy and should identify expansion goals in markets. And this is because it can get expensive when you have to have a different brand for a different jurisdiction. And I had a particular incident this year already where very, very successful Canadian brand all of a sudden decided they wanted to expand into the EU, and they didn't really think about their brand strategy before that. And turns out in the EU, there was essentially an identical brand. And the result was that they had to negotiate a sort of coexistence agreement, which can be done. But had they not been able to negotiate that coexistence agreement, they would have had to essentially rebrand in that market. And then brand strategy should always include appropriate trademark searches and a consideration of scope. And that starts from a provincial level too. If you don't do your due diligence at a provincial level in terms of what you want to brand and, you know, what you want to sell, you might find that you're limited to Saskatchewan only. And I don't think business is going that way anymore. We're becoming more globalized. And so brand strategy should be at the forefront of any entrepreneur's mind at this time. So with that, that is the entire presentation on business names and trademarks. And I would invite questions at this time if there are any.
Yeah, the questions should be in the Q&A box.
Okay.
I think there's four openings. The Q&A box should be on the bottom of your Zoom link or Zoom page.
All right. Just trying to find that. Sorry, guys.
So if you open up Zoom, is Zoom open?
Yes, I've got it. Sorry, it just was not allowing me to do it while sharing the screen. All right. So I have a question. Do you want me, so just answer these live? That sounds good.
Yeah.
So I have, what is the average cost for a sole proprietor company to trademark their word? So that really depends in terms of who you engage to do the work. So there's going to be your legal fees, and then there's going to be your government costs. So with legal fees, right now, when you register a trademark, the Canadian government charges by class of goods and service. So for a Canadian trademark, the first class of goods is $330, plus there's now a service charge of 2%. And for every additional class after that, it's another $100. So if you wanted to register, for example, skincare products and clothing, that would be 2 classes. And so you would have $430 plus the service fee. In terms of legal fees, it varies. So you can certainly reach out to me and I can provide you a quote. There's a few trademarks in Saskatoon who provide these services. Some charge the entire fee up front and some break it into phases. So it sort of varies there. I think the range is typically between $1,500 and $3,000 for the total process of legal fees, but again, it varies. So that one's answered. If you already know that someone else is using a similar name in a different country, can you still register a trademark in Canada? So the answer, it really depends, but typically, yes, you can still register that trademark in Canada, and that would give you the exclusive rights to sell goods and services under that name in Canada. You would just have expansion problems in the future if you wanted to sell into that country. You would either have to go under a different brand or you would have to negotiate some sort of coexistence agreement. Now that said, there's certain conventions and treaties in trademark law where if there is, there's one that's called the Paris Convention, where if you've registered a trademark, say for example in the US, you have 6 months from the date of registration to register it in Canada and to claim the priority date back to the US registration. So there are applications. So there are sort of situations like that where you might be prevented from registering in Canada simply by virtue of the priority convention, but that's a very remote issue typically. So hopefully that answers your question. We have a corporation. So there's a corporation that owns a software product and you want to trademark the software product name and its logo. You did the limited search on CIPO. Do we have to trademark the corporation first to the product? So no. Again, you would never trademark a corporate name typically, like the Lunova, like you would never go Luann Schlosser Legal Corp Inc. You would never trademark that suffix in there typically. You don't have to trademark the corporate name first. You can trademark the product name if you're using the product. So hopefully that answers the question. The next question is, if you don't have a trademark for your product name, Can another company copy the product and steal the trademark, the product name? Theoretically, yes. So how that works. So if you haven't trademarked the name, but you're selling under that name, and another company copies it and tries to use your name and they file for a trademark, you would have to oppose their trademark application, which can become costly. If they don't have a trademark, then there's other courses of legal action you can take against them. But technically it doesn't, if you don't have a trademark, another company could theoretically copy the name of the product. The next question is, you mentioned to see if your name logo is available. Where does one start to search? So the first thing you can do is you can conduct a search provincially. Like if you're just looking to register your business name or your corporate name, you can do that through ISC, through Corporations Branch provincially. Now, if you wanted to do a prelim search in terms of whether your trademark, your brand is available, there is a website that is the Canadian government's. It's called CIPO, so it's Canadian Intellectual Property Office. If you Google that, that'll bring you to a page where there is a button where you can select trademarks, and then there is a page where you can select search trademarks. So that's how you can do a search on your own and a preliminary search. And that'll flag direct identical hits. It will not flag anything that could be confusingly similar. It will not flag anything that is phonetically the same. The next question we have is, if someone blocks your application saying that the consumer would be confused, but you do not see any way that this could happen, is litigation the only recourse? So I'm assuming when you say if someone blocks your application, you're meaning the trademarks examiner. So when you file a trademark application, it gets examined. That's sort of the first stage after you file. And right now it typically happens 18 months to 2 years down the line, which is a long time, I'm aware. There's nothing you can do to speed up that process. But once your trademark application is examined, the examiner will then review the technical compliance of your trademark, and we'll look at the trademark registry to see if there's anything else out there that is pre-existing that could be confusing with what you're trying to register. If the examiner refuses your application based on confusion, you will have to try to persuade them that it's not confusing. If you can't do that, I wouldn't say litigation is the only recourse. You would have to sort of look at the previous brand owner and whether or not they had the right to apply for that trademark application, whether they applied for it fraudulently, are they actually using the trademark? So that's a bit of a gray one. It really is driven by the facts, but that's sort of a limited and general overview. The next question is, if you had a shorthand name in addition to your full business name, should you trademark both? Would it be separate costs for each one? So I'll start with the last part of that question first. So a trademark application is per trademark. So for each sort of trademark or logo you want to file, it's a separate application. So separate government fees, typically separate legal fees. If you shorthand name in addition to your full business, you would typically trademark the shorthand name, but it really depends, like how are you presenting yourself in social media? So for example, Sears Canada Inc., I know they're really not a thing anymore because they're under CCAA proceedings that I think are still ongoing. But when Sears was a thing, Sears had a trademark for Sears, because you would never say, I'm going to go buy a new dress at Sears Canada Inc. You would say, I'm going to Sears to buy a dress. And Sears would say, Sears catalog, here's Sears flyers, here's Sears sales, not here's Sears Canada Inc. So you would typically trademark whatever it is you are using as your brand, how you're promoting yourself. If you are using both, then you would be using both applications. Next question, when you trademark something that has a word, color, shape, and someone uses the word alone, is that an infringement? That really depends, because first of all, your trademark, when you file it, you have to file it in relation to certain goods and services. So if someone is using a similar trademark or the same trademark as yours, but in relation to unrelated products, then it's not typically an infringement. You would really have to look at what the scope is of what they're doing and what you have registered. So that's as far as I can answer that one without any further details. What would be the cost of registering a word, color, shape? I already went over that. Legal fees vary by trademark agent and firm, but the Canadian intellectual property disbursements are always the same, $330 plus the service fee for the first class, and for every additional class thereafter, $100. Next question. And I can keep answering these questions. I'm just not sure how long you guys want me to go. There's about 5 more. So the next question is, you have a word mark application, but the process takes so long to hear back. We are moving forward on the assumption that it will go through, but I decided to hold off on paying for logo slogan, additional cost until the word mark is approved. Now I'm worried about someone stealing these things as I gain momentum. Our trademark application for Canada, how do we go about registering? Okay, so this is a pretty long question. So for the person who posed this, you can reach out to me on that one. Again, once you register, just from a strategy standpoint, when you register a trademark, like a word mark, that gives you the ability to stylize that into different logos down the road. So that's the broadest protection. If you haven't done your logo or your slogan, it's not fatal. There may be some issues. And then without getting into another area of law, your logo itself has another type of intellectual property protection, which is called copyright. And that would arise on creation without the need to do anything further. So the minute that you created your logo and used it, you would have copyright in that. So that's a different area of law, but certainly feel free to reach out to me just because that's a pretty distinct question you're posing here. Do we have any power against cyber squatters and recourse in the social media while our trademark application is going through the long CIPO approval process? Great question. Yes and no. Depending on what your domain name is and what social media platform you are using, it varies because some require that you have a registered trademark. So that would mean one that's gone through the entire process and has successfully registered, whereas others use the definition of trade name, which would just mean a business name used. So that really depends. Next question. Do you recommend that people register the business name in each jurisdiction? Is there a way to register in all jurisdictions in Canada at once outside of the trademark process? I wouldn't recommend this because you're going to have quite a lot of fees across Canada, and you can achieve the exact same objective by simply registering a trademark. And a trademark, if I didn't say this already, which I don't think I have, trademarks are a type of intellectual property that can last in perpetuity, so forever, so long as you continue to use them and renew them. And the renewal periods for trademarks are 10 years, whereas in most jurisdictions, you have to renew your business name, I think it's every 3 years. And then for corporations, you have to, if you have a corporate name, it's tied to a corporation, you file an annual return every year. So from a cost and streamline process, I wouldn't recommend doing the business name registration in each jurisdiction. I would say go for the trademark. Next question. For e-commerce, selling handmade clothing, what do you recommend to trademark the brand or products? Okay, so a trademark is the name, and then you register the brand in relation to the product. So you would register your brand, not the products. You can't seek protection for like a handmade sweater. That does not attract intellectual property protection, but you can seek protection for your brand that you're providing your sweater under. So you would you'd want the trademark there for the brand. Next question. If you have a trademark registered and that same name is registered provincially, does that mean that both entities or individuals could carry on that business in the other jurisdiction? For example, if I have a registered business name in Saskatchewan and someone else has a trademark, does that impact my ability to use the registered name in Saskatchewan? Great question. Depends, and potentially. So people gain common law trademark rights in the jurisdiction that they operate simply by using their brand. So simply by using my brand, Lunova Law, in Saskatchewan and anywhere else I'm presenting or giving services, I gain what's called common law rights into that brand. So common law rights, though, they're limited. Common law rights are limited to the geographic area in which you're providing the goods or services. So you can develop common law rights in a brand by providing them. If someone registers a trademark, it would really depend when they started using their brand. So it would come down to priority, who was using the name first. And if that person has had the brand for more than 5 years as a registered trademark, we run into incontestability issues where they are presumed to have the sole and absolute rights into that name. And potentially they can use their trademark to force you to not use your name in your province. So that one again is quite fact specific, and you'd have to look at the time frame and the use of by each entity to have a proper answer to that.
I think that's all the questions. You answered 14 questions for us. Thank you so much, Luann.
You're
That was fantastic presentations, and I guess people were very curious about it. Thanks to all of you who took time out of your busy days to join us. Don't forget to check our events page at west.ca/events to register for the rest of our legal series webinars. And also we have an on-demand webinar available that touches on building intellectual property strategy, and I kept the link on the chat if any of you still have more questions. But as Luann said, you can reach out to her if you have any other questions. We'll be sending you the link to the presentation tomorrow, and along with some documents that Luann has prepared and is willing to share that summarizes her presentation. So thank you again, everyone, and have a wonderful afternoon. Bye.